We are on the record in the matter of People versus Latavius Trashad Thornton. This is case 25-203FY, and may I have appearances for the record, please?
George and on behalf of the people, Your Honor.
Thank you. And
I'm Melissa Vachon with the Office of the Public Defender, Your Honor. I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
okay, and Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavius Trashad Thornton, which is a nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like it's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn, okay? But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable, okay?
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir,
Mr.
Thornton. So if you want to appeal,
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavius Trashad Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But
yes,
there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, I mean, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights.
Before we dive into the courtroom chaos you're about to witness, let me set the stage, because trust me, this one is a case features one of the most classic, stubborn, and predictably unpredictable characters in the sovereign citizen universe. And if you're new to sovereign citizens, buckle in, because you're about to see why these interactions become viral gold every single time that we have a defendant who insists he's not himself. No, he's the representative of a non-profit organization that happens to share his legal name. And yes, he plans to argue that distinction with the confidence of a man who once skimmed a Facebook post about maritime law and decided it was gospel truth. On the other side, we've got a judge who has absolutely had it, someone who is calm, methodical, and armed with more patience than anyone deserves to have before coffee. This judge is about to break down constitutional rights, arraignment procedures, appeal protections, and the difference between a human being and an LLC, all while juggling one man's attempt to transform a felony case into a TED Talk on
Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. Well, no, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, We're going to talk about bond or bail. Okay. So,
Can I please ask?
because here's the thing. I don't want to be disrespectful to you.
Right,
And
absolutely.
I know it feels disrespectful, but here's why. Here's my concern. I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm fine with you doing most of it. But please, to protect my free speech, could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just send?
And there it is, the opening bell of the Sovereign Citizen Olympics, the refusal of one's own name. This is the moment every judge dreads and every viewer loves. When he says, "I object to being called Mr. Thornton," he's not just nitpicking, this is a core sovereign citizen tactic. They believe that rejecting their legal name somehow separates the living man from the corporate fiction, a concept pulled from pseudo-legal conspiracy theories that have never worked in any courtroom, anywhere. Judges hear this so often that you can practically see their souls leave their bodies. Notice how the judge doesn't get emotional or combative. She just keeps the train on the rails. Meanwhile, he's already creating a tangled mess, and we're only a minute in.
I'm well aware of that fully, Taylor Shaw Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial.
Moment right here is where you really see the judge struggling to maintain a courtroom rhythm. Arraignments are supposed to be simple: confirm identity, read charges, advise rights, set bond, done. 5 minutes. Maybe 10 if someone asks a question, but sovereign citizens turn a 5-minute hearing into a 45-minute philosophy seminar nobody asked for. The judge is trying to keep things organized because in real court, transcripts matter. Appeals matter. Clean records matter. But our hero here? He's playing 4D chess with rules that only exist in his imagination. Watch how she keeps reminding him, "I'll give you your turn," like she's negotiating with a toddler who wants to argue every instruction. And yet, she still maintains professionalism. That contrast is what makes these cases so fascinating. One side is operating under the law, the other is operating.
And I say unless for a reason, because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Saturday. Saturday is going to happen. Unless means we don't know what's going to happen. And in your case, we don't know what's going to happen. You haven't seen the evidence. Okay, I'm going to keep going through this and then I'll acknowledge you in just a minute. You haven't seen the evidence.
Okay.
No attorney has seen the evidence. The court hasn't seen the evidence. So you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at trial. And now I'm going to read the charges against you because you have a right to know them. Okay, you can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for?
I wasn't in trouble this time.
No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before
But
you get to
that's-
reading, can I make one statement, please,
Well,
Your Honor?
you can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor, and based that is why I feel it necessary for me to make certain things known for Latavius Treshaw Thornton, for that the script can, so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Latavius Treshaw Thornton to the courts. I have those full intentions. And so that you guys can be safe from all liability of Latavius Treshaw Thornton as his representation. That is the only reason why I speak in the way of please refrain from calling me Mr. Thornton and certain things, because it's pertinent for you guys to know I've already been treated as the surety. I am not the surety.
And here we have one of the funniest contradictions of the entire sovereign citizen playbook. They claim to be deeply offended by the idea of being called defendant, yet they willingly engage in behavior that guarantees they remain defendants. The judge even tries to be polite. I'd rather call you Mr. than defendant, because that sounds rude. But sovereign citizen logic is undefeated. If it sounds reasonable, reject it immediately. This is also where you see the judge trying to protect him from himself. She knows the more he talks, the worse it gets. He sees speaking as a right, she sees it as a liability. And she's right, sovereign citizens have a long track record of talking themselves into deeper charges, higher bonds, and competency exams.
And that the script goes a little different, and I understand that I understand me now, I have the right to let it be known that I'm not the surety, and nobody has, I'm sorry, and.
Okay. All right,
Yes,
so
ma'am.
here's
Your Honor.
Here's the thing. That's okay. That's not an issue. So here's the thing. I don't know if you remember when a guy named Mitt Romney was running for president some time ago. And he said, and he really upset people with this, he said, corporations are people, my friend. And a lot of people made fun of him, but corporations are people. So that LLC would be a person in the eyes of the law. But a person does not become an LLC. But regardless, we're going to read these charges because you have a right to know them. So in count 1, you are accused of police officer assaulting, resisting, and obstructing, contrary to Michigan law MCL 750.81D1. This is a felony punishable by up to 2 years in prison and or $2,000 in fines. In count 2, you are accused of assaulting, resisting, or obstructing a police officer. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. Lastly, in count 3, you are accused of, again, assaulting, resisting, or obstructing a police officer. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. And this is alleged against the peace and dignity of the people of the state of Michigan. Now we're going to talk about your rights. You have the right to an attorney, and today Attorney Vachon is standing by. If you can't afford an attorney, the court will provide one for you, and we have superb public defenders in the.
Spoiler alert *, you do not have First Amendment rights in a courtroom the way you have them on the street or online. Courtrooms are structured environments. Judges control the floor. If everyone had unlimited free speech during hearings, nothing would ever get done. Imagine a trial where anyone could interrupt, object, or argue at any time. There'd be fistfights before opening statements. The defendant thinks he's defending his liberties, the judge is actually protecting his legal position. The irony is almost poetic. Meanwhile, he keeps talking about dignity, honor, and rights bestowed by